Hello, my name is Alistair Hodge, and can I welcome you to this hour-long session on experts, what to expect in cross-examination. What am I hoping to achieve over the course of the next hour or so with you? Well, what I hope to be able to do is provide you with a comprehensive guide to the art of cross-examination. We're going to firstly, in the opening section, look at how the advocate approaches the cross-examination of an expert, because many of you who are watching will, of course, be expert witnesses and experts in your own particular field. In order to be, if you like, cross-examined well and indeed perform well in cross-examination, it strikes me that it's important to know the fundamentals as to how the advocate is approaching the cross-examination of you. Once we've dealt with those fundamentals, we'll move on into some tips as to what you might expect during the particular cross-examination that you need to endure. And the final section is very much some words of wisdom, some anecdotes, some stories as to when I've cross-examined expert witnesses and really what to do and what not to do during a cross-examination. Let's then lay some foundations, if we may first, before getting to cross-examination itself. Obviously, if you are an expert in a criminal case, you will, of course, before the cross-examination, have had to go through the process of examination in chief by your own friendly advocate. In other words, what they will do in a criminal case is ask you a series of questions, invariably beginning with who, what, where, when, why, how, describe, in order to tease out of you orally the evidence that is contained within your expert report, because all evidence in the criminal jurisdiction is given orally. Whilst you have probably prepared an expert report, you must therefore be totally at one with that report and know its detail inside out, because you will be asked questions about it to translate its written content into oral evidence. If you're an expert in the civil jurisdiction, it's a very different kettle of fish. Whilst, as I mentioned, in the criminal jurisdiction, you'll be given a bit of bedding in time because your own advocate will be asking you a series of questions about your own evidence. Invariably, in the civil jurisdiction, it is your expert report that will take the form of your evidence in chief to the court. What does that mean for you as the expert? Well, it means that effectively you're thrown into the deep end of cross-examination at a very early stage in the process. And many experts with whom I've worked over the years, who do both work in the civil jurisdiction as well as the criminal jurisdiction, have pointed out to me that they feel far more comfortable being cross-examined in the criminal jurisdiction because they've had that opportunity orally to state the contents of their report and give effectively their own evidence before the tiger advocate on the other side gets underway with the questions in cross-examination.